Thank you.
SJC-11445, Commonwealth v. Henry Walker.
Yes, counsel, good morning.
Good morning, Your Honors. May it please the Court, Joseph Keneally for Henry Walker. Your Honors, it's important to note here from the outset, Mr. Walker was determined to be a sexually dangerous person, and he was committed to the Massachusetts Treatment Center for a term of 1 day to the remainder of his natural life. I would submit that given the potential length of stay, it's important here to reiterate the position argued by counsel for Mr. Fay that an interpretation of the civil commitment statute in such a way that allows for the indefinite and potentially lifelong commitment of someone who is not a risk to commit a non-contact or not a risk to commit a contact or non-violent offense is in fact a violation of due process. It's been said that due process requires a statute that allows for preemptive commitment to be narrowly tailored. However, the current interpretation of this statute, which I would submit allows for virtually any crime to qualify as an enumerated sex offense, and allows for the indefinite, potentially lifelong commitment of any individual who is not even a risk to lay a hand on another person, is the antithesis of a narrowly tailored statute. I'd suggest that, to my knowledge, the interpretation of 123 as it stands in this case is as expansive as any civil commitment statute in this country, and goes beyond anything that the U.S. Supreme Court has suggested or has been called upon to suggest is consistent with due process. Now, Your Honors, as to Mr. Walker's case, it comes to this court in a slightly different context than the two companion cases, because in this case, Mr. Walker indeed has been convicted of a contact-based offense. The governing offense in this matter involved an indecent assault and battery. He was alleged to have rubbed up against a woman at a mental health facility where he was also located at the time. I would submit, Your Honors, that the fact that he has been convicted of a contact-based offense should not be the determinative issue in deciding this appeal. And the reason for that, Your Honors, is because it is not so much, civil commitment is not so much based on what it is that an individual has done in the past, but the determination from the fact finder as to what the individual is likely to commit in the future. And I would say that the most important issue driving civil commitment is not even necessarily the method of offending, but in fact the harm that accrues as a result of that, the likelihood of offending. I'd suggest that it isn't what an individual is likely to do necessarily, it's the harm that he's likely to cause as a result of the actions he's likely to take. And I'd submit that that matters in this case, because as the trial judge found, and I would submit he found unequivocally, the only harm that Mr. Walker was likely to inflict upon a potential victim was shock and alarm.
How about touching?
There's no suggestion in the judge's decision, which he read aloud in open court at the end, that he would likely commit a contact-based offense on another individual.
That's the one that where he said there's a substantial possibility?
Well,
A significant possibility.
what he said was
Significant
he said was that a non-contact offending was likely, and he said, but there's a significant possibility that he would commit a contact-based offense. Now, this is clearly the issue here in terms of what the judge's ultimate decision was in terms of what he was likely to do. Mr. Walker was likely to do. I'd submit that when you look at that statement, what he's saying is a non-contact-based offense is likely, but this is also possible. Now, I would note in the Commonwealth's brief that they refer to the judge's language here as a significant probability, and I think that that was just a perhaps an unintentional error, but I think that the distinction is critical, because there's a difference between a possibility and a probability. And I think that this court in Boucher said that something being possible is not sufficient to qualify someone to prove likelihood to commit a sex offense. I think, Your Honors, that you also have to look at here is getting away necessarily from the contact versus non-contact based offensing. As Attorney Robinson said in the last argument, it might not be necessarily an issue of drawing a line. What you need to look for is what it was, what kind of harm it was that the judge found the defendant was likely to cause if he were released. And time again, the only reference he made to the harm that was going to accrue was shock and alarm. He said it 7 times during his decision. Not one time did he say, I find this man likely to commit a contact-based offense.
Well, but he didn't have Suave. Should we be remanding for?
Well, Your Honor, I think that what happened is, in these circumstances, the judge made clear what he found. And I think that part and parcel with, so the short answer is no. What he found was part and parcel with his determination that what this man was going to do was to go out and commit exhibitionist offenses. He said over and over again that when he talked about the quality of the menace that Mr. Walker was likely to pose, he actually contrasted the menace, the harm he thought that he would be likely to commit with a contact-based offense. On volume 3, page 67 of the transcript, he states, many sorts of sexual offenses carry with them a great deal more potential for harm to other human beings than does exhibitionism. No one would seriously contend that masturbating in public is as harmful as rape or indecent assault and battery. And then he says no one could even possibly argue that contact offenses are not far more concerning than the seriousness of the harm threatened by Mr. Walker. What he's saying here, essentially, is we know that what's going to happen isn't as bad as a contact-based offense. We know that what's going to happen here is not going to be of that nature. But the judge decided, given the fact that what he does, what Mr. Walker is likely to do, is to cause shock and alarm in his victims, that is sufficient to warrant a determination that he's a menace to the health and safety of the public.
Now, let's assume, for the sake of argument, that we do remand back to Judge Broussard, and that Judge Broussard says, I do not find a likelihood in the post-Suave world, and therefore I find him not sexually dangerous. What's the practical consequence for your client, since your client, I believe, has been later found in a post-Suave world to be sexually dangerous?
Well, I think that there's an interplay here with the McIntyre case in this one. And I think, frankly, Your Honors, that this case can be significantly distinguished from McIntyre in 2 ways. There's a practical way, and there's also an analysis of the law. And then the practical aspect, Mr. McIntyre, it took him 8 years to take his 2002 appeal to this court. During that time, he had 3 subsequent Section 9 adjudications. He was 5 years out after, he was appealing his case for 5 years when the second one came in. In Mr. Walker's case, Mr. Walker's Section 9 adjudication took place 5 months before it got to this court. And he has been appealing this case with all due diligence. I mean, he filed his notice of appeal, he brought it to this court. If, in fact, the appeals court had ruled, we would submit appropriately in determining that Suave warrants a remand or a reversal in this case. We wouldn't be here today because that case was argued and decided before the Section 9 petition, and it was also argued before, obviously, further appellate review was granted here.
But I still don't know what happens. I mean, let's assume we don't view it as moot. Let's assume we do send it back or we reverse it. You still have an SDP adjudication as of, I think, July of this year.
I think that leads into the legal aspect of it, because in order for an individual to be found sexually dangerous under during the course of a Section 9 proceeding, one of the elements that the Commonwealth needs to prove is that he has been previously adjudicated a sex offender, a sexually dangerous person.
It's a finding of remaining a sex offender, STP. Under
Yes,
9.
exactly.
Yeah.
But one of the elements that the Commonwealth needs to prove in a Section 9 proceeding is that he was previously adjudicated. Now, if this is remanded and reversed, then that adjudication goes for naught, and the Commonwealth therefore could not have met their burden under a Section 9 proceeding. And in that instance, they would not have been able to prove. So that I would suggest that would result in a dismissal of the subsequent Section 9 too. That's a different situation from McIntyre, because in McIntyre, what he was appealing was a Section 9 hearing after another Section 9 took place. And in a footnote in McIntyre, this court said, because there was a previous adjudication, there was an initial commitment proceeding that took place. The government is insulated. They have already established that there was a previous adjudication that happened. So, but in this case, it'd be a completely different situation. So
Is your client, now he's being held on this, but for the conviction that he recently got on the indecent A and B, Right, he did, right?
He was convicted of indecent assault and battery and open and gross lewdness. Those were the two governing offenses, Your
Okay.
Honor.
But recently, right? Is that,
No, he was...
but I mean, what happened to him that was the subject of your letter? He
No,
went
it
to-
was a subsequent Section 9
Oh,
proceeding
just the
that I was bringing
Section
to the
9
court's
proceeding, I'm
attention.
sorry.
Exactly.
Okay, I'm sorry, yeah.
I see my time. If there are any other questions, Your Honors?
Thank you, sir.
Thank you.
Good morning. May it please the court, Mindy Klenoff for the Commonwealth. I'm the trial prosecutor on this case. With me is Zachary Hellman, who briefed the case. The trial judge here properly found that the respondent was a sexually dangerous person when, based on the evidence presented at trial, he found that the respondent's mental abnormality produced both the contact and non-contact offending in Mr. Walker, and as well substantively found that he was likely to commit both contact and non-contact offenses in the future.
No. Do you agree that you misrepresented on page 29 of the brief what Judge Broussard said?
Are you referring to the probability?
Yes, he never said that, did he?
No, he said a significant possibility.
Isn't that a huge difference?
That's a significant difference in language. Ultimately, however, reading the lengthy findings as a whole, it's clear that Judge Broussard believed that the contact and non-contact offending would be the fruits of the mental abnormality in the case.
I mean, he said on page 30, I credit Dr. Murphy's testimony that Mr. Walker will likely engage in future non-contact offenses, so you have a finding of likelihood as to non-contact offenses, but that there is certainly a significant possibility of future contact offenses. Is it your view that a finding of a significant possibility is sufficient to meet the Boucher standard for likelihood?
I would refer the court to the appeals court references to Daigle and Walsh, which call a distinct possibility and a good possibility sufficient on likelihood. Additionally, I would comment that in this case, the defense does not argue sufficiency. They agree that the evidence was sufficient,
Right.
and
the
that
issue
is
is not-
relevant.
Right. The issue is whether Judge Broussard found a likelihood of future contact offenses. He couldn't have, of course, found the post-Suave standard, but don't we have to remand it because we don't know whether Judge Broussard found that there was a likelihood of future contact offenses or found that there was a likelihood of future non-contact offenses that would trigger the Suave exception?
Based on the findings as a whole, the entire 17 pages, there's really quite a few references to the contact offenses, and specifically, the judge actually says, I don't credit Dr. Bard that the contact offending is simply a criminal act and not the result of a psychological disorder. I believe he testified non-persuasively, Judge Broussard said, that there was no relationship between any disorder of Mr. Walker and the contact offense. So he is opining, or finding at least, that the mental abnormality encompasses the production of contact and non-contact offending, and his likely offenses will encompass the range of non-contact and contact offending.
If that were the case, one would think that he would use the same language. I mean, the fact that he used distinct adjectives and nouns to describe, to draw, difference between contact and non-contact offenses seems to me something we can't ignore.
What the judge did was actually to mirror the language in the testimony by Dr. Murphy, which the defense agrees was sufficient to engender a finding of sexual dangerousness. He used the exact same language that Dr. Murphy used, likely and significant possibility.
But Dr. Murphy is starting from the premise, which I think the judge disagreed with, hey, if he's guilty of anything, whether it's contact, non-contact, a sexual offense as defined in 123A1, then that's enough.
Right. Judge Broussard made very detailed and very nuanced findings, crediting parts and not crediting parts. But the testimony on likelihood was the same testimony on likelihood that Judge Broussard repeats in his findings, which is a likelihood of non-contact offending and a significant possibility of contact offending. The contact offending in this case takes up half of Mr. Walker's offending. In addition, there was strong evidence of uncharged conduct in psychiatric hospitals on multiple occasions, based on the Bridgewater reports quoted in the records. There's indications that he was going into patients' rooms at night, that he touched a patient's leg and said, "When are we getting together?" That he was warned multiple times about sexual misconduct, that he was placed on one-on-one watch. There was a significant amount of evidence suggesting that Mr. Walker was an unusual exhibitionist and one whose behavior rose on a regular basis out of the scope of his offending to higher level behavior, to contact offending or offending which would otherwise trigger SWAV. And many of Mr. Walker's, or I should say the offenses, the non-contact offenses Mr. Walker committed, which are attendant to the contact offenses, I would argue do rise past the SWAV standard.
But he didn't make any finding in that regard.
Of course, Judge Broussard did not have the benefit of SWAV. But in many ways, he did anticipate it by talking about the contact offenses and talking about the way in which they were part and parcel of Mr. Walker's offending and part and parcel of his mental abnormality in the case. The court has no further questions.
Thank you, counsel.